Okay, this is Western Michigan University Political Science 325 Distance Learning number 7. That is from week 14, April 16th. Punishment, chapter 9, sections 9.13 through 9.16. That's actually pages 476 to 485 in your book. I want to spend a few moments talking about the concept of punishment and whether or not there is constitutional protection against a court or the government being involved in punishment. And the answer to that question is yes, there is. The Eighth Amendment, which we've talked a little bit about so far when talking about bail, also states that cruel and unusual punishment shall not be imposed. Actually, the particular phrase says excessive fines shall not be imposed, nor cruel and unusual punishment inflicted. So the government is not permitted to impose cruel and unusual punishment, so says the Eighth Amendment, and cannot impose an excessive fine. So these are things that the government as well as the court need to be aware of. It's important to understand that the federal Constitution says cruel and unusual punishment, which means if a particular state decided it wanted to impose cruel punishment, but it was not unusual, the U.S. Supreme Court would not reverse that type of punishment because it is only both cruel and unusual punishment that is protected. I should pause right now. I'm looking at the camera and realize I am wearing, instead of a Western Michigan shirt, University of Michigan. So I apologize for anyone who's offended by that. One thing that differs between the federal court and some states, including the state of Michigan, is Michigan's Constitution says that its state actors cannot impose cruel or unusual punishment. So it's a little bit different. In Michigan, you only have to show one or the other in order to get relief within the state. Again, as we've talked about since the beginning, a state can afford its citizens a few more rights than what the federal threshold requires. So that's an interesting little change between a state and the federal government. The word or, as opposed to the word and, makes a big difference when it comes to Eighth Amendment protection. Cruel and unusual punishment contemplates contemporary standards of decency. And, of course, it changes as public opinion changes. Over the years, what we have thought might have been cruel and unusual before may not be cruel and unusual now, and vice versa. So there are hosts of cases that examine this Eighth Amendment because as we develop as a people, as a society, our opinion about what is cruel and what is unusual type of punishment may change. And that's why this has to be examined on a regular basis, depending on the punishment. This applies whether or not it's a fine, whether it's a term of probation or incarceration, which means if you're going to impose a fine worth $1 million, if it's excessive, it's going to violate the Eighth Amendment. If you're going to impose probation, for example, a lifetime term of probation, that may be found to be cruel and unusual under the federal standard, or in Michigan, cruel or unusual. And the same is true regarding the length of incarceration. More often than not, people race to the discussion of the death penalty when we're talking about the Eighth Amendment, cruel and unusual punishment. And I don't want to spend a whole lot of time talking about it, but we should spend some amount of time. Up until the early 1970s, each state made a decision about whether or not they wanted to permit the death penalty in certain circumstances. This was across the board around the country, a wide range of types of cases and whether or not a particular state would permit the death penalty. I wouldn't go so far as to say it was like the Wild West, but there was not a whole lot of uniformity. And people were being executed in some states because of a certain crime that was committed that they wouldn't get anywhere near execution if they had committed the crime across the border. The Supreme Court had ruled that the imposition of the death penalty was not in and of itself cruel and unusual. But as states developed their practices, there tended to be quite a bit of disparity amongst the various states in terms of the imposition of this type of penalty. So we have a case in 1972, which is referenced at page 479, Furman versus Georgia. That's Furman. In that particular case, the Supreme Court, having examined that which was particularly happening in Georgia as well as around the country, invalidated the capital punishment laws in the country. It did so because those procedures violated due process. There was unguided discretion on those bodies, whether they were a judge or a jury, that were sentencing people regarding the imposition of the death penalty, which ultimately the Supreme Court found led to random and unequal justice. And as a result, we start in 1972 with Furman versus Georgia with somewhat of a clean slate. That is, invalidate all the death penalty laws. Each state has to look a fresh look at those types of cases where they will consider imposing the death penalty. What we have now over time, since that Furman decision, the Supreme Court saying there must be 5 characteristics that exist in a particular state and with a crime that will afford the state the opportunity, if they wanted to leave open the possibility of the death penalty. Now, of course, a state doesn't have to have that as an option, and Michigan is one of those states that does not have a death penalty option, no matter what the crime. But if, in fact, there's a state that chooses to have as part of its sentence possibility the death penalty, the Supreme Court says that there must be 5 characteristics that exist. So let's talk about them. The first one is that the underlying crime necessarily must have involved a death. That is, in order for the court or a jury to impose the death penalty, have that as an option, there must be a victim of a crime who actually died, which means if somebody went out and committed numerous sexual assaults, whether they be on adults or children, and nobody died, the Supreme Court would not permit the death penalty to be imposed because there was no death. So the first criteria is that the underlying crime necessarily must have involved a death. That comes from Coker versus Georgia, which is page 746. It doesn't matter how gruesome or grotesque, you need to have death of a victim or victims in order to consider imposing the death penalty. There was a case recently, well, I should say within the last 10 years or so, in the state of Louisiana, where Louisiana had decided to change their law and wanted to impose the death penalty on somebody who had committed a sexual assault against a child where the child did not die. So they changed the law. An individual by the name of Patrick Kennedy was charged with and convicted of child sexual assault, and he was sentenced to death. And he appealed his case up to the U.S. Supreme Court, and the Supreme Court denied Louisiana's ability to kill him, that is, execute him, because even though it was a grotesque, gruesome crime, the victim in that case did not die. So there have been efforts to try and remove that as a condition, but as it stands right now, the underlying crime must have involved a death. This does not speak to federal crimes such as espionage and treason, which are in a category in and of themselves. I'm talking about state crimes and whether or not an individual is subject to the death penalty. The second of the 5 requirements is that the judge or the jury, whoever's doing the sentence, and each state decides who does the sentence on such a matter, the judge or the jury who does the sentence must have the discretion to decide whether or not the death penalty is appropriate. What that means is that it's important for whoever's making the decision to have the ability to say, we will impose the death penalty or not impose the death penalty. In other words, you can't treat particular defendants as members of a faceless group. You need to individually examine this particular person and ultimately have the decision to decide, should his life be spared or should he be executed? In other words, there is no mandatory death penalty requirement, meaning that if you commit X crime, that you must then die. Individual sentencing has to be individualized sentencing, has to be part of the process and built into the legislation for that particular state. Third requirement is that the statute from that state that says that if you do X, then you may face the death penalty, must also have within its language aggravating factors. That is, there must be an effort on the part of the state to suggest a particular set of aggravating factors that would warrant the death penalty. In other words, simply committing a murder does not warrant the possibility of the death penalty. There has to be something that's aggravating about that murder. For example, if it was the murder of a police officer, if it was the murder of somebody following or in participation of a rape, there needs to be at least one aggravating factor beyond the simple commission of the murder that would suggest the death penalty as an option. The state of Georgia attempted to challenge this recently in Godfrey versus Georgia, which is referenced at page 480. Georgia said that when a murder, quote, was outrageously or wantonly vile, horrible, or inhuman because it involved depravity of mind, they put that language in their statute and wanted to have as an opportunity to execute somebody who commits a murder with that type of aggravating factor. And the Supreme Court ruled that that was insufficient. It was not an objective aggravating factor that differentiated between murders, and therefore it was insufficient. So we're back to the types of things that are the murder of a child, the murder of a police officer, the murder following a kidnapping or rape. Things of that nature are the types of things that we look at when we talk about specific aggravating factors. So, one, we got to have a death of a victim. There needs to be some discretion on the part of whoever is imposing the sentence. And three, we need to have at least built into the statute an aggravating factor or a list of factors that must exist before an individual may face this possibility. The fourth requirement is that if the defendant is convicted of the crime, he must be given, or she must be given, the opportunity to provide at the time of sentencing mitigating factors to demonstrate that the jury or the judge, depending who's doing the sentence, might be able to show compassion and show mercy and withhold the death penalty. In other words, once somebody is convicted, you have to open up the door for the defendant to bring in those people, bring in that evidence, so that the sentencer, the judge or the jury, whoever's doing it, has an opportunity to look at this individual and decide based on mitigating factors. He was abused as a kid. He suffered injury when he was younger. He was a good person through most of his life. Whatever those mitigating factors may be, to give that sentencer an opportunity to avoid imposing the death penalty. So that's the fourth requirement. Things like the age of the individual, their good character, their lack of a criminal record. The state of Ohio attempted to put a cap on the time and effort and the amount of mitigating factors, and the Supreme Court ruled in Lockett versus Ohio that you can't limit that. You have to afford a defendant an open door to provide whatever they feel as though is appropriate as a mitigating factors in order to attempt to convince the sentencer to spare the person's life. I say that because oftentimes the sentencing portion of a death penalty case lasts much longer than the conviction portion. Why? Because there are no rules of evidence, and the defendant who was convicted has free rein to bring in whatever they feel is appropriate as a mitigating factor. Which leads me to the fifth and final requirement, that is, the sentencing phase of this process must be distinct from the trial phase. That is, you go through the trial to determine the individual's guilt, if they're in fact guilty, and then you begin the sentencing phase. They have to be distinct. They can't roll into one. Many states choose to use the same jury that made the decision on guilt to decide whether or not the death penalty is appropriate. Some states leave it up to a judge to make the decision. Some states bring in a whole new jury to hear the evidence again and the defendant's mitigating factors and permit and then make the decision at that point. So there has to be a distinction between the finding of guilt and then the sentencing portion of it. Um, the reason for that are multiple, including the fact that at the sentencing, the defendant has the opportunity to present whatever mitigating factors they want to, and those may not be relevant to the issue of whether or not he was guilty of the crime. And again, at the trial, the prosecution, the defense are limited to the rules of evidence in order to have the jury make a decision as to whether or not the person should be held responsible for the crime, that is, if they're guilty. So we have a sentencing phase that's distinct from the guilt phase, and it's important that that be part of a statute if a state chooses to have the death penalty as an option. So those are the 5 things that a statute in those states that want to have that as an option must include in their particular language to afford themselves the opportunity to impose the death penalty. A couple things about the death penalty that you should understand about who cannot be executed. Someone who is facing an intellectual disability, the case of Hall versus Florida from 2014, says that the state cannot impose the death penalty. Anyone who was under the age of 18 at the time of the crime, that comes from Roper versus Simmons from a 2005 case, which overturned a 1989 decision in Thompson versus Oklahoma, which set the age at 16 years of age at the time of the crime. Now, anybody who commits the crime under the age of 18 cannot be subject to the death penalty. So we want to make sure that intellectual disability as well as age may prohibit, even though all those other factors exist, may prohibit the particular state from imposing the death penalty. A few years ago, there was a gentleman in Ohio who was involved in a very serious murder, terrible crime in Akron, where he was accused of and ultimately convicted of throwing rocks on an overpass, hit a woman who was sitting in a car, killed her. Terrible set of circumstances. That individual was ultimately convicted. He was sentenced to death. While he was on death row, he asked that he should be excused from being executed because he was obese. That is, his weight and his the amount of fat that was with him subjected him to be spared his life, to fall in the same category as someone who was intellectually disabled or they were a youth. The Supreme Court ruled against this individual and said that it was not permitted, his execution was not going to be stayed as a result of him being obese. Interesting case out of the state of Ohio, particularly Akron. There are a number of problems associated with the death penalty we want to at least mention briefly about. Despite these attempts to make it an individualized decision, there's still significant disproportionality in the imposition of the death penalty. In the case of McCleskey versus Kemp at page 482, an African-American male tried to argue through statistical evidence that Georgia's system impermissibly permitted racial considerations. And that individual demonstrated that an African-American male was 4 times more likely to get the death penalty as opposed to someone who was not in that category of individuals. So this was an attack not on simply the crime that the individual committed, but the imposition of the death penalty was still, through statistical analysis, not fair across the board, and wanted to spare this individual wanted his life to be spared because even despite those 5 things that the Supreme Court had ruled, Georgia seemed to be, not just seemed to be, but the statistics showed that they were executing people who fit that category 4 times more likely than others. The Supreme Court looked at this case, again, McCluskey versus Kemp, in a 5-4 decision, admitted that the system was not perfect, but decided not to change it, meaning they did not buy the argument presented by the petitioner in that case, and his execution was permitted to go through. Some other moral, ethical issues. Other states have imposed a moratorium on the imposition of a death penalty. The state of Illinois is a good example of that. A number of years back in 2000, there was a governor by the name of Ryan, and because of some advancements in DNA testing and some other information regarding prosecution, before he left office, and as a side note, he left office a bit in disgrace as he was convicted of corruption. But before he left office, he decided, as was his purview as the governor, to commute the death